Recording.
Good evening, everyone. My name is Jen Tremin, and I am the program manager with the Atlanta Beltline Partnership. Tonight, we are partnering with the Atlanta Volunteer Lawyers Foundation and the City of Atlanta to bring you this workshop on eviction protections during COVID-19. To begin, we'll hear some opening remarks from Atlanta Beltline Partnership Executive Director Rob Bronner and the City of Atlanta's Chief Housing Officer Terri Lee. Afterwards, volunteers from the Atlanta Volunteer Lawyers Foundation, Ayanna and Darius, will give us more information about renters' rights in the state of Georgia, the eviction process, the information on the CDC moratorium on evictions, and different options for assistance in the city of Atlanta. At the end, we will have an opportunity for Q&A with our presenters. So if you're joining us on Zoom, just enter those questions into the chat box and we will get to as many as we can. And with that, I will turn it over to Rob to say some welcoming remarks.
Thank you, Jen, and thank you everybody for joining us this evening. I hope above all that you all are safe and well. My name is Rob Bronner. I'm Executive Director of the Atlanta Beltline Partnership, and we're the nonprofit entity that supports the vision for the Atlanta Beltline as a catalyst for equitable, inclusive, and sustainable city life. This includes the creation and the preservation of mixed income communities so that residents ultimately can live and work and thrive along the Beltline. And one of the ways that we do this is through our home empowerment workshops like this one tonight. You know, we believe that the Beltline brings a lot of positive health and economic and transportation benefits to the neighborhoods that it connects. But we also know that both renters and homeowners can feel that they're being pushed out due to rising housing costs. And we understand especially that during this pandemic and COVID-19, there's a tremendous amount of uncertainty and anxiety, and that the financial pressures may be felt more severely now than ever. And we want to do what we can to be able to help you be able to secure your home, right, and remain in your community. And we are very grateful for funding from Wells Fargo and Bank of America that's enabled us to provide these workshops throughout the year and to connect Beltline residents with partners and with resources that can help you stay in your home. Past workshops have covered a variety of topics, and they are all available to watch at beltline.org/empower. And tonight you will learn about eviction protections from our partners at the Atlanta Volunteer Lawyers Foundation. Ayanna and Darius have a very informative presentation for you. And my one request of you this evening is that if you find this workshop to be helpful, and certainly hope that you will, please tell your neighbors and anyone else you know of who needs help, who could benefit from this. Please tell them about it to help us get the word out. I'm also very, very grateful that we are joined this evening by Terri Lee, who is the Chief Housing Officer for the City of Atlanta, and who has also recently been named the Chief Operating Officer for Atlanta Housing. So Terri is, absolutely the biggest leader for affordable housing in this city. Her leadership and her partnership have been instrumental in advancing Mayor Bottom's One Atlanta Housing Affordability Action Plan. And I can say personally, she has challenged the Beltline Partnership, the Beltline, our partners in very positive ways to make sure the Beltline is truly for everyone. Terri's a trusted friend, a trusted partner, and I am grateful that she is with us tonight, and we'll turn it over to her. Terri?
Rob, thank you so much. And please give me the opportunity to just honor your leadership with the Beltline Partnership. We've been at this a long time with the Beltline, and your commitment to equity and to equitable development should be commended. It has not been an easy task, and I would say to you all this evening, I think the pandemic has shown us this. I wish we were in a room together so I could ask for a show of hands for people to just reflect upon where you were on Friday, March 13th. Right? Friday, March 13th, 2020, quite honestly, is when many of our worlds just completely changed. And at that time, we were told that we needed to stay at home. But what happens when you don't have a home or you don't have a stable environment to go to? That's what we were faced with as a country. And the things that we've been talking about for so many years, is the need for additional affordable housing, the need for stable housing, the need to ensure that people have quality access to safe, decent, and affordable housing became just a very real life conversation. In addition to that becoming a real life conversation, we also recognize that for the first time, this recession would hit not just people of median means, but it literally would hit people who were already struggling from day to day to pay their rent, as well as to pay their mortgage. We recognize here in the city of Atlanta that out of the total number of households we had about 16,000 households that directly would be vulnerable as a result of the recent pandemic. We literally again saw the collision of not just housing, but of housing and public health. When we think through the conversation tonight, I again would like to commend the Beltline Partnership, Atlanta Volunteer Lawyer Foundation, as well as Atlanta Legal Aid, along with Bank of America and Wells Fargo. Because what you're here tonight are the actual rules to the eviction protections that have been set forth by the federal government as well as the local government. But what I would tell you is that they're eviction protections, not eviction forbearance. And one of the things that we're finding is that rent will still be due. And so if I can urge any of you tonight that are listening, and even if you have friends and family that are not listening, for you to share this valuable information with them, because what we do not want to have happen is just a massive eviction filings once any of the protections are lifted and people actually be made homeless. We at the City of Atlanta have dedicated about $22 million in federal funding to the United Way of Greater Atlanta to administer an emergency rental assistance program. I will give some news tonight that will be made public on tomorrow, but so whoever's on this call will be the first to hear. We're expanding that program to also include mortgage assistance. What we have found since the start of the pandemic, and as we continue to stay in this environment, is that help is needed for not just renters, but also for homeowners. We're also finding that even though these are federal dollars, we need to try to be as flexible as we possibly can. And that's flexible within the federal rules and guidelines, but still trying to meet our constituency where they actually are. And so we're committed to doing that at the City of Atlanta. We thank our partner, United Way of Greater Atlanta. And we also thank Atlanta Volunteer Lawyer Foundation. They're one of the recipients of a portion of the $22 million. And I'm sure you'll hear more about their program tonight as well. Again, I thank each of you for just the opportunity to share with you this evening, and I just urge you to take the information you hear here and to share it broadly so that we can help as many people as we possibly can stay safe during this critical time. Thank you.
Terri, thank you so much. I'm glad to hear that that was extended. That's really great news. So now I will turn it over to our partners at Atlanta Volunteer Lawyers Foundation, Ayanna Jones-Lightsey and Darius Woods, to give us more information on eviction protections.
Good evening. My name is Ayanna Jones-Light. Sorry, I'm trying to do two things at once. My name is Ayanna Jones-Lightsey, and I am the co-director for the Safe and Stable Homes program at Atlanta Volunteer Lawyers Foundation. So we're really excited to be here with you tonight to talk about some of the eviction protections that have been put in place by your local and federal governments. And first, we're going to start by just giving you a little bit of information about Atlanta Volunteer Lawyers Foundation. Our mission is to create safe and stable homes for families by encouraging the fight for equal justice among the private law sector. We've been in Atlanta for about 40 years, and we've been very blessed to be able to provide protection and representation for low-income tenants all across the city of Atlanta. We are the largest provider of pro bono legal services, and we are proud to stand with our low-income tenants and also our survivors of intimate partner abuse. We have a second side to our office that deals with intimate partner abuse or domestic violence. It is our privilege to be able to harness the power of our professional community to provide free legal and social services. So tonight's agenda is your rights as a renter in Georgia, understanding the eviction process, the CDC moratorium, and the rental assistance programs that are available to you. If you have a question, there will be a period for question and answer after this presentation is over. We will also try to monitor the chat, but please know that some of the questions that you submitted, hopefully those answers will be found in the following presentation. So the first thing you want to know is, what are your landlord's basic obligations to you as a renter, and what are your obligations as a tenant? The landlord has a duty to repair. That is critical for you to understand. They have to maintain the premises in habitable conditions, and they have to do things like replace appliances if they were initially in the unit. We hear a great deal from tenants who say, my refrigerator broke, my oven, my stove broke, the landlord didn't fix it. If those things were in the unit when you initially entered into your contract, they need to be repaired by the landlord. The landlord also has an obligation to return your security deposit within 30 days of your move out, or send you an accounting of the charges against that security deposit. They also have to provide you a certain level of notice or a demand for the premises before they can even file an eviction in Fulton County Magistrate Court. In addition, there are federal protections, including non-discrimination against for race, gender, or disability. They have to disclose certain things before you rent the place. And if you are in subsidized housing, meaning things like Section 8 or Atlanta Housing Authority, there are some additional regulations that HUD puts on the landlord. As a tenant, though, you also need to know that you have some obligations. You've got to comply with your lease. And most of us, I know we don't, but it's really important that at least initially when you sign that lease, you should read it. Because if and when you ever have to go to court, the judge is going to be looking to that lease. And that lease is going to specify what is considered a violation of that lease, such that the landlord would take you to court. You need to notify your landlord promptly and preferably in writing of any repair issues. That protects you, as well as ensures that your rights are being respected. And finally, upon your move out, you should complete a move out checklist, take pictures of the condition of your unit when you move out, and make every effort to return any keys to the landlord. So let's talk about the eviction process. What are some of the basics? And please keep in mind that since March 13th, that fateful day, there have been some alterations to the process. I'm going to give you a basic overview of eviction, and then I'm going to let you know what has changed or been altered since COVID-19 hit Atlanta. Evicted is a book that was written by Matthew Desmond, who is one of the leading speakers, researchers on the effects, the ill effects, the negative effects that eviction can have. It's not just losing your home, it's losing your stability. It can impact your schooling. It can impact the neighborhood. So it's really important that we take a long, hard look at the eviction process as it stands. The first thing, and if you don't remember anything else from this workshop, Georgia does not allow self-help evictions. Under no circumstances can a landlord evict a tenant without a court order. I'm going to say it again because it's really important. No self-help evictions. During the eviction process, the tenant is allowed to remain in possession of the property. That means your landlord cannot change the locks, cannot put your items on the street, and cannot cut off the utilities. There has to be a court order signed by a Fulton County magistrate judge that orders you off the premises, that says you no longer have possession. Outside of that, it is an illegal eviction, and there are certain penalties. There was a question put forward prior to this presentation. What can you do if the landlord is illegally evicting you or improperly evicting you? If you think that is a possibility of happening, I'm going to tell you a couple of things. One, make sure your current address is on your driver's license. If that is not possible, I suggest you carry around with you in your wallet, in your purse, in your car, some proof that you live at that residence. That means a utility bill, mail, anything that you can think of that demonstrates you are a current resident. Because what you're going to do is take that document to the police station and tell them that your landlord is evicting you. Sometimes what happens is people go to the police stations and they say they're being evicted, but the police officer has no proof that you actually live there. And so their hands are tied. You need to have that proof. Be prepared. Keep it with you, because like I said, those are actionable items in court, and there is no self-help eviction process in Georgia. The landlord must have a court order. The first part of the eviction process is that the landlord must demand that the tenant give up possession, that the tenant leave. This demand is best made in writing, but there is no magic language that has to be used. Sometimes that demand comes in the form of a text message stating, I want you out within 30 days. You need to get that demand, and it needs to be very clear. If you're in subsidized housing, sometimes that can look like a notice of termination of lease or an intent to terminate. And additionally, in subsidized housing, it generally gives the tenant a right to request some type of informal or formal conference to contest the proceedings. You absolutely have rights. Unfortunately, there's no set timeline for this demand. So pay attention to the things that your landlord is saying. Step 2, the landlord must file a dispossessory warrant under oath in magistrate court. And the warrant must state some specific things. It must state the name of the tenant. It must spell out the reason the tenant is being removed, which is usually a lease violation or non-payment of rent. There's a verification that the landlord demanded possession before filing this dispossessory warrant. And if there is an amount of rent or other money owed, it must be spelled out in this dispossessory warrant. Sometimes landlords will get into court and demand a much higher amount. If it's not in your dispossessory warrant, if it's not in the paperwork that you were served, and the paperwork that you were served doesn't say that it accrues, the amount you owe accrues, the landlord can only ask for that amount specified in the dispossessory warrant. After filing the dispossessory warrant or the eviction, based on a specific cause, non-payment of rent, the landlord cannot accept rent from the tenant. If your landlord accepts rent, even partial rent, this can be grounds for you to request the court to dismiss your action. So if you are able to negotiate with your landlord after they file the dispossessory warrant and you give them cash, a money order, you write them a check, you give them a credit from your credit card, get it in writing, preferably beforehand that this is the agreement. Get a receipt, because this is your proof that the landlord has acquiesced and has accepted the rent and is allowing you to stay on the property. This is for your protection. This is an example, I know it's probably tiny on your screen, of what a dispossessory warrant looks like. The language can be confusing. Sometimes, a lot of times, we get calls. Let's say I've been served with an eviction. This is the official court document that comes from Fulton County Magistrate Court. It needs to have your name on it. It needs to have the landlord's name on it. And it needs to have a case number. Outside of that, there's a good chance that it is not actually an official eviction from the court, and it's more like a notice that they intend to terminate. As you can see on here, the landlord has to state specifically why they are seeking possession. After you're served, well, let's talk about after the landlord files, there has to be service. That can be personal service where the sheriff or a process server comes to your door and actually hand delivers it to you, or an adult who lives in the household. Your children, your minor children are not considered competent enough to accept service. So if your child gets a copy of something from the sheriff, that's not proper service, because let's be honest, children are forgetful. And so these things have deadlines, and it's very important that it's a competent adult who accepts that service, not a minor or a disabled adult who's been deemed incompetent. As I stated, it can be served on another adult in the home. It can also be tacked to the door of your unit, but that is only supposed to be used if someone competent is not at home. Tack and mail, it can be problematic in and of itself because things happen with notices that are attached to your door. But it is a way that the landlord is allowed to serve you with notice. The deadlines still apply. Once you receive your dispossessory warrant, your summons, you should also know that it can be filed electronically. What you need to do is look at the bottom of this eviction notice. I'm going to scroll back so you can see what I'm talking about. At the very, very bottom of this letter, of this slide, you see defendant to answer on or before. That is a critical date for you as a tenant. You've got to file your answer on or before that date. If you don't, there are some serious consequences, but it will always be at the bottom of your dispossessory warrant. The date is usually 7 days after this notice has been served on you. If the 7th day is on a weekend or a holiday, the answer is not required until the next day that is not a weekend or a legal holiday. Please pay attention to this next part. If you fail to file your answer on time, the landlord can go back to the court and file an affidavit for a writ of possession. Those are usually signed by the judge within a day or two. That writ of possession is what the sheriff's office uses to come and put you out, because essentially you have not filed an answer. You are in default, and the landlord is saying, I want possession sooner. So it's critical that you file your answer on time. Even if you're not sure of what to say, file your answer and then consult with one of the legal entities that we're going to talk about a little bit later, because you can change or amend your answer to be more accurate, but at least get an answer in on time. This is what an answer will look like. There are several boxes that you can check. Some of these boxes, if you check the wrong box, the landlord can then still ask for a writ of possession. What we're looking for is whether or not you have a reason, a valid legal reason for why you are fighting this dispossessory answer. The second part of that is a counterclaim. A lot of tenants fail to fill out this counterclaim. The counterclaim is basically, I have some arguments or some things that I want the court to take a look at. Not just the fact that my landlord has filed this dispossessory answer, but my landlord owes me money. My landlord failed to repair the property. Since my landlord didn't make these requested repairs, I made them, and that cost me this much money. Or my landlord's failure to repair the property cost me some money, some damages to my person and or my property. Don't leave that blank. If you have something to say or share that you want the judge to hear, fill that counterclaim out as well as your answer. The next step, and some of this has been altered since COVID, is the hearing. When you file your answer, that same day, that same moment, the clerk will give you a hearing date in normal circumstances. So that you'll know before you leave court that day or after you file your answer when your hearing is. If some reason you cannot attend the hearing on that date and it's a valid reason, you should in writing request a motion for continuance. Put your name, the landlord's name, the case number, motion for continuance, and what is your reason? I have a doctor's appointment. I'm in the hospital. I'm incapacitated in some way, shape, or form. You want to try to make sure to get an extension of the time. I do need to caution you, these are not guaranteed to be granted, and oftentimes they may not be granted until the day of court. Typically, again, pre-COVID, there were dispossessory hearings scheduled every single day of the week. And on 2 of those days, there's a special set of hearings for tenants who did not raise a proper defense. And these are the tenants that get surprised. They thought they filed their answer, and the judge asks you to stand up and says, I'm going to issue a writ of possession and you need to be out of your place in 7 days. Those are scary, and you want to make sure that you do your best to file a valid answer. Also, pre-COVID, mediation was available for up to 2 hours if you decided you wanted to attend. Mediation is when you go in a room with the landlord and a third party who's not the judge, you try to reach an agreement. If you are able to reach an agreement, it's called a consent agreement, and it will be drafted by the neutral third party. And what you need to understand is you cannot appeal this agreement. Once you sign it, once the judge signs it, it is final. So be very, very sure about what you're agreeing to. You're entitled to a hearing. And if you want the judge to hear what you have to say, don't enter into a consent agreement. Go in front of the judge. This is an example of a consent agreement that you might see. There's always places to write things in. You don't have to go by exactly what this says, and you want, to the best of your ability, to understand what it says. If you have a question, you have every right to ask the mediator, what does this mean? What is it saying? So let's say the worst case scenario happens. You do not file your answer. Your answer wasn't a proper defense, or you've had your hearing and you lose at the hearing. The landlord can then go before the judge and ask for a writ of possession. This is what the application for the writ looks like, and this is what it looks like when it's actually been signed by the judge. These usually happen fairly quickly, and once the judge signs them, the sheriff is authorized to come to your residence and remove your belongings. Some of the timing is just based on the sheriff's list of people. For a little while, these writs were suspended. They weren't being served by the sheriff's office, but they are now back to being served. You do need to know, though, it can potentially be dismissed if the landlord has accepted rent after the writ was applied for. One of the things that the landlord has to swear is that they did not accept any rent money from you. So if that's the case, you might have a good argument. Now we're going to talk about how COVID changes things. So between March and June, the magistrate court suspended hearings. In-person hearings are still not really happening until November, which is 2 weeks away. So the orders were extended, the emergency orders were extended. However, as far as we know, that extension is due to run out November 2nd, and the court will be back to its pre-COVID procedures unless something happens. And you can always check the Fulton County Magistrate Court's website to see if that's the case. If you have already been served with a hearing notice, you should have gotten something that said, are you willing to participate in a Zoom hearing? Because they are allowed. However, in order for the Zoom hearings to proceed, both sides must agree. So if you as the tenant do not agree to a Zoom hearing, then the hearing cannot proceed. If the tenant has properly filed an answer with a good enough defense to merit a hearing, meaning the judge thinks let's have a hearing, and one or both of the parties do not agree to a Zoom hearing, then no legal eviction can occur. There's a lot of ifs in this statement, and if you are at all confused, you need to consult with an attorney to try to get some advice about whether or not an eviction is legal. But again, there's got to be that court order signed. Usually it's a writ, but it could be an order from the hearing that says you have to get out by 7 days. 7 days is the legal limit of the amount of time that a judge can give you. If you enter into a consent agreement for a larger amount of time, that is allowed, but pay attention to those deadlines. So now I'm going to turn it over to my colleague, Darius Woods, to talk about the CDC moratorium.
Hey everyone, and thanks Ayana for that valuable information. And special thanks to Jen, Rob, and John with the Atlanta Beltline for putting this together, and Terri and Bithia with the City of Atlanta for helping organize and partner with us as well. My name is Darius Woods. I'm a staff attorney with the Atlanta Volunteer Lawyers Foundation, and I really focus in the West Side neighborhoods. So area codes or zip codes 30314, 18, 30310, and 30311. And we run a school-based clinic out of the West Side neighborhoods. I'm going to give you a little information about the CDC moratorium. Then I'm going to go down to rental assistance because I know a lot of people have questions about rental assistance. But first, as you see, that CDC moratorium, I don't know if you've heard about it, but the Center for Disease Control issued a moratorium on September 4th, advising courts and local authorities that they shall not proceed with evictions if a tenant files the CDC affidavit. And we'll get to the affidavit later. So all this does is temporarily halts evictions between September 4th and through December 31st for tenants who are being evicted for failure to pay rent. So this doesn't cover any other issues for you being evicted. So for example, if you're being evicted because of criminal activity on the property, the CDC moratorium is not going to help you. If you're being evicted because your lease is up and your landlord has already notified you that they did not intend to renew your lease, then the CDC moratorium won't cover you. So what is an eviction? Under the CDC guidance, an eviction means any action by a landlord, owner of residential property, or other persons with a legal right to pursue an eviction or possessory action to remove or cause the removal of a covered person. So what does this mean? This does not mean that a landlord cannot file an eviction against you during this time period. Your landlord can still file an eviction against you. However, they will not be granted, they should not be granted an eviction, the right or a writ of possession, as Ayana just spoke to you about, during this time period, so long as you fill out and return that affidavit. So, for example, if an eviction has been filed against you and you're scheduled for a hearing on November 2nd or soon thereafter, if you've already submitted the CDC affidavit, you should not be actually removed from the property at that point. Now, we still have a little confusion over when that will happen, whether it will happen immediately, January 1st or soon after. That is still vague and that hasn't been clarified as of yet, but you will not be removed from the property. It also means, say you have already, eviction was filed against you back in March and a writ of possession was issued against you today, for example, and the sheriff comes in 7 days, but you file a CDC affidavit before the sheriff comes, hypothetically, you're supposed to be able to use that proof that you sent that declaration to your landlord to stop the sheriff from actually removing the items from your property. So this comes into play at any time during the dispossessory process because it's meant to stop your stuff from being removed and prevent you, if you're facing eviction, from being homeless. And then it just gets a little complicated thereafter. But the whole idea is as long as you send in this CDC affidavit, you should not be removed from your property before December 31st. Okay. Now, Ariane, if you could go to the next slide. Who's covered by the CDC moratorium? So what we find is that most of our clients are usually covered. One, you have to have received the stimulus check, or you have to have income of no more than $99,000 a year if you're single, or $198,000 a year if you're filing your returns jointly. You must be unable to pay rent due to loss of income or extraordinary medical expenses. Now, you don't have to show this to your landlord. Your landlord, and I've dealt with situations where landlord has requested proof that a tenant is unable to pay rent. Now, you may have to show that later if the landlord tries to challenge your affidavit that you fill out, but you do not have the affirmative duty to show your landlord that you suffer extraordinary medical expenses or that you lost income. The declaration is going to be your signal, your sign that that you're covered and that you suffered a loss of income. The third thing you have to do is you still, like I mentioned before, the third thing is you would become homeless or need to double up if evicted. So in the affidavit, it says you have to affirm that if you are evicted, if a writ of possession is granted and the sheriff removes your stuff from the home, that you would become homeless or need to double up with family. And four, this is really important, that you still are required to make partial payments using the best efforts to make timely partial payments, and as close to the full payments as possible, given your individual circumstances. Now, I know that's loaded, but essentially is you have to pay as soon as you can, as much as you can. In order to be covered by this moratorium. You also need to have applied or attempted to apply for government programs, rental assistance programs like the United Way and several other rental assistance programs that we're going to go over. Now, before we get into the key points, I just want to talk, how does someone use these protections? You use these protections, and it's important because this is one of the rare situations where you have the affirmative duty to submit a CDC declaration. Now, that declaration could be found on the CDC's website, and you see the link to the CDC website is there. You can also easily find it just by Googling or Yahoo, or whatever people use nowadays, and put in CDC declaration, eviction moratorium declaration. And that should bring up the declaration. There are also some online versions that allow you to fill out the declaration online, sign it online, and send an email directly to your landlord without all the paperwork. And one that I know for sure is the Kentucky Justice Center. They have an app, and even though it's in Kentucky, it's fine because this is a national moratorium. So you can use whatever resource you find to help you submit this declaration as easily as possible. Now, if you've already been evicted, then unfortunately, this declaration doesn't apply to you. I know I get questions for people who have gone through the process already, and they wonder if they can use this declaration to get back into your home. Unfortunately, if you're already evicted, then the damage has already been done, and the CDC doesn't cover any of these situations. And I'm going to repeat this again because I know that people are confused by this and wonder, do you still owe rent to your landlord? And I'm going to emphasize, you still owe the full amount of rent to your landlord. You will be able to make partial payments, but that doesn't relieve you from your obligation to pay the full rent. So for example, if December 31st comes and you've made partial payments, but you still owe a significant amount as far as the months that you're behind, unfortunately, that amount isn't going to be forgiven. The CDC doesn't have rental assistance programs tied to this moratorium. That's why obtaining rental assistance is going to be your best bet prior to anything like that happening. Now, another thing is, because this is affiliated with the CDC, I know I've heard people, clients call me telling me that they called the CDC and trying to find out they can get a representative from the CDC to help. Don't call the CDC. I mean, they're not going to help you. They just issued this guidance, and they really this is the most and probably the best that they can do at this time. So that's why it's important to contact our office if you have a situation that you think you need legal assistance with, or the Atlanta Legal Aid or another legal organization like Georgia Legal Services. Now, if an eviction has been filed against you and you want to appeal it based on the CDC moratorium, the appeal, that's not something you're going to be able to do, but because this doesn't relieve you of your obligation to pay rent. And if an eviction has been filed against you and you appealed it, you're still not going to be evicted from the home. Exactly. So if it's for failure to pay rent, it's really no point of appealing it. In most situations, I recommend filling out the CDC declaration, because that's going to stop an eviction from moving forward, rather than trying to appeal the eviction, citing the CDC declaration, because it's just a temporary halt on evictions. It doesn't really do more than that. I'm also going to repeat again that you can be evicted for other reasons other than non-payment of rent. And some examples that the CDC gives are engaging in criminal activity while on the premises, threatening the health or safety of other residents, damaging or imposing immediate and significant risk to property, or violating applicable building codes. Now, what we have seen is some landlords have tried to find other reasons to proceed with an eviction, because they understand that they can't get you out for failure to pay rent. If this is your situation, or if you know someone in this situation, I definitely encourage you to have them contact one of the legal organizations in the city of Atlanta to get help, because I've seen a lot of the times these other reasons for eviction are kind of made up in some circumstances. And if it is made up, you want to make sure you have legal representation to help you argue that actually isn't the reason for their eviction. Okay. Now, the key points, as you see on this slide, it only applies to non-payment of rent cases. It expires December 31st, so you want to use your best efforts to try to get your full payment made prior to December 31st. It requires that you complete the declaration, and there's the website for the declaration. It allows for partial payments, but you still owe back rent. Sorry. And so this is an example of the CDC moratorium. I advise you read it carefully before you complete the CDC moratorium, just because you don't want to perjure yourself. There's penalties, criminal penalties associated with lying in the CDC affidavit. So make sure you read it carefully to make sure you qualify for this declaration before you submit it. And these are the things that we already went over. Use your best efforts to obtain assistance. Income qualify. If you're unable to pay in full, you must be unable to pay in full due to substantial loss of income, layoffs, or extraordinary out-of-pocket expenses. You also need to use your best efforts to obtain assistance through one of the local assistance programs. And I saw someone, and I know a lot of chats. I've seen like at least 5 or 6 chat messages come in. I saw one that asked specifically about late fees, and no, the CDC moratorium does not waive the late fees. However, the Fulton County Magistrate Court has signaled that they do not want to see a ton of late fees being charged against tenants who suffered as a result of COVID. So just keep that in mind. I know that there are some landlords who are charging extraordinary late fees, like $100 a day, for the first 5 days, and people are becoming thousands of dollars behind because of late fees. Uh, those, it's highly unlikely that a judge would grant those extremely high late fees. Now, you may be required to pay some late fees, but it should be within reason, given the circumstances that everyone is going through at this time. And then this is the last page of the CDC declaration. You have to declare that you'll be homeless or have to double up with someone. You understand that you still pay your rent, and this only lasts until December 31st. You sign it, you return it to your landlord. Now, if you don't use one of the apps to return it to your landlord, that will automatically send an email to them to keep a record. It's important that you keep your own record. So take a picture. Take a picture of it for yourself, email it. So you know the exact date, the exact time when you sent it to your landlord. Make sure, or just make a copy of it, but make sure you keep a record that you submitted the CDC declaration, because, like I said, if a writ of possession is granted and a sheriff shows up at your house, you should be able to show them the copy of your declaration and proof that you submitted it, and they should leave, because only during this period, though. But they should leave once you show them that. Next slide. And before we go to rental assistance, I'm going to try to answer some of these questions. So I think I already answered Tommy's question. Do tenants have to provide proof of loss of income? No, you don't have to provide proof of loss of income. But however, it is important that you're being truthful. So if you lost income due to COVID or due to some medical expense, just be truthful. And I think that's the most important thing. I hear what constitutes a rental? If 3 people with 3 different leases, does one person qualify? That is an excellent question. Excellent question. So everyone in the household, minus kids, should submit the CDC declaration. Everyone in the household. So, for example, if you're living in a rooming house, and there are some other tenants, and you all are associated with each other, each tenant should submit the CDC declaration. If you are living in a home with your spouse, and y'all are both on the lease, then both of you should submit the CDC declaration. Any adult in the household who is on the lease should submit the declaration to the landlord. This other question: if you live in Atlanta, are you eligible for Fulton County mortgage assistance? I'll have to get back to you on that one, because I'm not really sure about the mortgage assistance program. And if due to COVID, pandemic, loss of work, etc., you run out of money and need to move before the end of the lease term, what can your landlord do? Can they sue you for the balance of your lease? Also, excellent question. So if you run out of money and you want to move, I would say in this situation, you may want to negotiate with your landlord. You definitely want to negotiate with your landlord to see if, in exchange of you moving and maybe getting into an agreement to pay a small amount, but some amount, that they will agree not to come after you for any money any balance that you owe. In my experience, landlords, they have been willing to agree to such deals because, as you can guess, they're also losing money when tenants can't pay. So in exchange, they have been willing to let some tenants move out of the property in exchange for not having to go through the dispossessory process, because this is going to be potentially a long process for them. Even though the courts are opening back up in November, there are cases still pending from January that haven't had a hearing yet. And of course, there's going to be precautions. We see this weekend, Atlanta Public Schools said they're not going back to school to 2021. So I think it's really going to be strict of how many people can be brought into the court. So just keep that in mind and use that as a negotiating tool if you want to negotiate a move out instead of your landlord filing an eviction. In my experience, a lot of landlords have been willing to make that exchange.
If I could jump in, Darius, real quick too, also look at your lease. Some leases have early termination procedures. And so if you are able to follow that procedure, if you are able to give enough notice, if you are able to do the move out, again, I will second with Darius in that landlords are willing to allow this. There is a housing crisis. So there are 10 people waiting for your apartment, 20 people waiting to get into your apartment, and the landlord is not trying to lose money. So see again what you can do, see what your lease says, and ultimately get every single agreement that you make in writing. If that's text, if that's email, but get it in writing and save it, because that will protect you if and when you ever have to go to court. You can show that as evidence of your agreement.
Yeah, exactly. Exactly. So this is what you see on the screen is an eviction, an assistance checklist. And it's important that you follow this checklist because it's just going to make it a lot easier on you as you're applying for rental assistance. The first thing that's important is, has an eviction been filed against you? Or have you received a notice from your landlord with them threatening to file an eviction against you? If one of these situations apply, then at that time you may be ready to get rental assistance. Most rental assistance programs are going to ask for proof that you're facing eviction or you have been threatened with eviction. So make sure that's checked off. Then next step, have you filed a CDC declaration? Now, different rental assistance programs have different timelines of how fast they can get back to you. So it's important that regardless if you're getting assistance and you think assistance can bring you current, file the CDC declaration just in case, because you want to protect yourself and give your landlord notice while you also attempt to pay off whatever debt you owe. You also need to ask yourself, do you need financial assistance? It's possible that you may not need financial assistance if you just found out that unemployment, your back unemployment check is going to come and you still haven't received it since March, which is going to be like a big lump sum. Then you might not need rental assistance. And the CDC declaration might hold you over until you're able to get that those unemployment or other benefits. And another thing you want to do, and I encourage people, a part of our organization is also encouraging, our clients to advocate for themselves. And this is a situation where I think it can go a long way to advocating and negotiating a repayment agreement. Negotiate. Just because your landlord tells you you're behind, of course, and your landlord is asking you to pay, hundreds and hundreds of dollars in late fees, try to negotiate those late fees away if you can, because that's going to make more funding available to you to pay off, the amount that you actually owe. So negotiate a repayment agreement. And then when you negotiate that repayment agreement, make sure everything is in writing and make sure a repayment agreement is realistic. I know a lot of my clients in the past and present have entered into a repayment agreement that they can't afford. It's just not realistically possible. If your repayment agreement says you're gonna pay $1,000 a week for the next 9 weeks, that's not affordable. I can't afford that. And that's not gonna be affordable for most people, especially and all people who qualify for that CDC moratorium. So make sure that you can pay whatever repayment agreement that you get into. And if you need help, and if you want to talk to somebody about a repayment agreement, you can speak with a HUD certified housing counselor. They're going to help you financial plan and budget and help you work through the process and find out exactly what you can afford to repay. You can also reach out to our office, the Atlanta Volunteer Lawyers Foundation, the Atlanta Legal Aid Society, Housing Justice League, a number of housing organizations who can help you and walk you through the process to make sure you don't get into unaffordable repayment agreement. And the next thing, so now I think this is what most people were waiting for. How can you qualify for rental assistance program? So as Terri mentioned, there's a program sponsored by the City of Atlanta through United Way, and our organization is one of the servicers for those funds. But if you're looking for assistance, just make sure you follow these steps. If an eviction, find out if eviction has been filed against you. You can find out if eviction has been filed against you by going to that public records access.fultoncounty.ga.gov. You can also just go to the Fulton County Magistrate Court website and search the court docket. You can search your name, find out if an eviction has been filed against you, because that's going to be important. And if eviction has been filed against you and you realize that you missed the answer deadline, reach out to an attorney as soon as possible to see if there's some way that you can they can argue that you should be allowed to file an answer. In most situations, it's going to be unfortunate situation. You might not be able to file an answer, but it's still important to try because there may be some things as far as service goes that your landlord failed to do that might allow you to file an answer. And if you get filed an eviction like in the next couple of days, or if you know someone who recently got filed with an eviction, we have a housing court assistance center at the Fulton County Courthouse, and our coworker there, Viraj, he will help you file your answer to evictions. He's right in the clerk's office where you file the answer. You really can't miss him when you walk in the clerk's office. It says housing court assistance center. You just visit him, and he will walk you through the process and help you file your answer and counterclaims if you have them. Then, as I mentioned, you want to submit that CDC declaration because you don't want to waste too much time. You don't want to put yourself in a bind if rental assistance is taking longer than you anticipated, because realize you are going to have to turn in certain documents through the United Way. So it may be a process. So make sure you fill out that CDC moratorium, just to make sure nothing is going to happen and no sheriff is going to come to your house to try to evict you. Now, financial. So rent, utilities, and other assistance is available, but most programs help with rental assistance. But utility assistance could possibly be available. You can see that keyword. That's where you can text the United Way. You can also visit avlf.org/United Way, and we have a ton of information specifically for City of Atlanta residents who may be able to apply for rental assistance through our office. And so you qualify. This is how you determine, and the best thing is going to do is going to be able to reach out to the United Way or visit us at avlf.org. But as you know, there are income requirements. You can see for a single person, the maximum income limits is $34,000, and for a family of 6, it's $57,000. So the income ranges, but I would say a good amount of people will apply, qualify, but it's best that you reach out to the individual assistance programs to see what their individual qualifications are. So individuals who are impacted and need support can apply in multiple ways. They offer this application in English and Spanish. The easiest thing to do is going to be to text that number that was on the previous page. And you can also just type in United Way Atlanta Rental Assistance, and it's going to have that number for you. Or you can text this keyword and be directed to an application page. You can go to our website. If you are a City of Atlanta resident only, you can go to our website and try to apply the rental assistance through our website. But texting 211 or speaking to a live person by calling 211 is going to be your best bet. I see someone ask, is United Way assistance available to other metro counties or only in Fulton? United Way rental assistance through the City of Atlanta, the funds that came from the City of Atlanta are only available to City of Atlanta residents, but there are other United Way programs for other counties in Fulton County. Your best bet is going to be able to go to United Way of Metro Atlanta, and it's going to tell you about tons of rental assistance programs that are available to you. And if you still have trouble, if you call the 211 number, they will direct you to someone who provides rental assistance in your specific area. Now, I only really know about the 5 metro counties. So Clayton, Cobb, Gwinnett, DeKalb, Fulton. I don't know if you live outside of those 5 counties. I'm not 100% sure. Ayana, do you know if there are other rental assistance programs?
There are some other smaller rental assistance programs, sometimes through the churches, sometimes through the shelters, but 211 is going to be your best bet to call. And really, if you can, get online to United Way, and there's a access portal that allows you to type in your specific zip code, and then it will pull up a list of agencies that provide rental assistance based on your zip code. Some of these rental assistance programs are just very small, especially in the rural counties. And so they're only listed via the church website, or they've accessed United Way website. So go onto United Way website and type in your zip code. And that's going to be one of the best ways for you to try to figure out if there is assistance in your county.
Yeah, exactly. So your best bet, 211, and they're going to be able to direct you to a variety of rental assistance programs.
Also, sorry, Georgia Legal Services services the majority of the counties outside the metro Atlanta area. So they may also have something on their website, Georgia Legal Services Program, that you can try to figure out if there are some rental assistance programs.
So if you were to go to our website, if you're a City of Atlanta resident, and you go to avlf.org, that's United Way, what you would see is all the information to help to go through the process of applying for the United Way funding. So step 1, you'll be filling out the United Way's application. And then if you're a City of Atlanta resident, you can select Atlanta Volunteer Lawyers Foundation, or AVLF, as your preferred provider, or you can call our hotline number if you need help. That information is on our website at avlf.org/United Way. And you can find all the information that you need regarding rental assistance for residents of the City of Atlanta. So now, time for questions. I think I got to everyone's questions in the Zoom chat. I know some people said they're going to reach out to me separately for an individual question, but if there are any general questions, we'll be happy to answer them.
I'll also say, for some of the mortgage related questions, you'll receive a follow-up email tomorrow with the recording of this video, which again, please share with people you think could use this information. But I will also link to the Atlanta Strong website through the city, who might have the update that Terri Lee mentioned in the beginning, as well as a video that we did back in May that did cover some CARES Act protections for mortgages. Some of it may be outdated, Darius, but some of it may still be relevant for those that are asking about mortgages.
I did see some questions that were forwarded to you all before the presentation that we can try to address that may not have been addressed in the program. So one of the questions was what to do after the moratorium is lifted. So I'm going to tell you 2 things. One, there has already been a challenge by landlords associations to the CDC moratorium, figuring out whether or not it's legal. From the National Low-Income Housing organizations, they feel that this is the CDC definitely had the authority to do this, and they feel like they have a strong case. So hopefully it won't be overturned. But once the moratorium ends January 1st, as Darius has mentioned,
you need to know that all of that back rent is due. And so landlords will be authorized to proceed as normal. And in Georgia, that means that once they file that eviction dispossessory warrant, you have 7 days to answer. Usually hearings are held within 10 to 14 days after the answer is due, and you could be out within 3 to 4 weeks. It's very, very important that even if you are unsure, you potentially need to file an answer just to give yourself the most amount of time. Because if you don't file an answer on that 8th day, the day after the answer is due, and you don't file an answer, the landlord can go to the court and request an affidavit for a writ of possession, which I've mentioned is usually granted within a few days. And the sheriff can come and is authorized by law to put your things out. So don't wait. Don't wait until January 1st. Do everything in your power to try to stay in your residence, to make an agreement, to file your answer, to follow all proper procedures. And when in doubt, reach out to Atlanta Volunteer Lawyer Foundation if you're in Fulton County, Atlanta Legal Aid Society. If you are outside the Fulton County, reach out to Georgia Legal Services Program. We are all doing our best to try to assist. There's also the Housing Justice League. And Darius, I don't know if you want to throw in any more organizations that you know of that may be able to provide some consultation or advice on these issues.
Yeah, I think all those recommendations as far as the resources that are available in Atlanta are great. And I noticed some more questions that we received prior. Someone asked, does this CDC moratorium cover single family properties? Yes. So if you're renting a single family property, you're covered. Now, I think some confusion might be coming to play based on the CARES Act. If you all remember, and if you qualified under the CARES Act only covered federally subsidized properties. It was restrictive to those properties. However, the CDC moratorium is not restrictive to federally subsidized properties. It covers all rental properties. It covers evictions from all rental properties. Some other questions I see here. It says that you got an eviction letter from court. What can you do? I think Ayana went over this pretty well. The first thing you need to do is make sure you file an answer. This CDC moratorium is not going to halt or stop your answer period. You still only have 7 days to file an answer. So if you have received an eviction letter or dispossessory warrant and you've been served, then you must file an answer within that 7 days, because the CDC moratorium is just going to keep you from being removed, but you're going to forfeit your right to dispute whatever your landlord claimed in their eviction filing.
Another question that I saw was, what do I do if I am living in hazardous conditions and nothing is being done? So hazardous conditions are repairs and conditions are our bread and butter at AVLF. And Atlanta Legal Aid. The landlord, no matter what else we've said, has a duty to repair and to keep the premises in habitable conditions. So if you are living in hazardous conditions, you need to send notice, make a repair request to your landlord. I know it can be a hassle, but to do it in writing is going to be your best protection, because it is an unequivocal duty to repair the premises. And if there are any damages as a result of the failure to repair, you have a counterclaim. So if your landlord hasn't filed an eviction, but you're living with mold, you're living with an extensive rat infestation, the ceiling is unrepaired, there's a huge sewage leak, you're not supposed to be living with those things just because we're in quarantine. You're not supposed to be putting up with those things. The landlord has a duty to repair. Make a repair request in writing as many times as you need to. Text it, screenshot it, send it, drop it off at the office, whatever you need to do. Those are your best protections. And if and when necessary, you can sue your landlord for affirmative damages based on what you have suffered. If you have asthma, if your child has asthma, a respiratory condition, and is living with mold, you have some rights. So please protect those rights by making sure you make those repairs in writing. That is going to be critical, because what it becomes is a case of he said, she said when you get to court. They never told me they needed repairs. And then what proof do you have? You really need to have that proof. You really need to make that effort to keep a copy of your repair request. You are not supposed to be living in hazardous conditions, especially during this time of COVID.
Uh, Another question that I saw, it was about rental assistance, and it said if the landlord, if you try to get rental assistance through a rental assistance program, and the landlord rejects that rental assistance and still tries to evict you. Now, I actually have the situation now. If that happens, you may have a defense that you try, to get rental assistance to your landlord, but he didn't accept it. I've never actually raised that defense, but because most landlords, in my experience, have been willing to accept rental assistance, especially given that the CDC moratorium wouldn't allow them to actually get you out of the property until January 1st, pretty much at the earliest. So most have been willing, but if this does happen, I would advise you to, call AVLF, call legal aid to help you work through this. But it's possible that it could be used as a defense on your eviction filing. Ayana, do you have thoughts about that?
If your landlord is refusing to accept and you have a full payment with late fees, you again want to try to text the landlord, I have your full payment plus your late fees. And you want to get a response back that says they are not accepting it, because in some instances you have a defense of tender. So when we say defense, we don't mean that it shouldn't be filed and that you may not have to go to a hearing. We just mean that a judge is more likely to rule in your favor because the law is on your side. Does that stop landlords from filing? No, it absolutely does not. Does it stop your landlord from arguing with you? No, it does not. It is still a process. You may still have to fight and stand up for your rights, but it just means that the law is more so on your side, so that if you have to go in front of the judge is going to say, I agree with you. So you want to show any proof that you have that you've attempted to tender. I'm also going to stress, do not, if at all possible, give your landlord or your landlord's representative cash unless they sign a receipt, because cash disappears. And we don't like to think that there are unscrupulous people out there, but the reality is, if your landlord says you didn't pay and you only paid with cash, you have no proof. You have no proof that you paid. And it's not a good situation to be in. Spend the extra $1 or $2 to get the money order and keep that receipt. That's the other part of it. Keep a receipt or take a picture of it so it can be traced.
And I saw another question on here, and this one was from a landlord. And primarily our objective is to represent tenants, and we do not provide legal advice to landlords. But this question was a relevant one because it asked what assistance programs are available to landlords. There's an organization called Star C. I don't have their website in front of me, but if you type in Star C on Google, they are a program specifically for landlords, and they want to partner with landlords to help tenants pay their rent. They can tell you more about their specific program, but if you're a landlord on this call and you are in a position because you need to pay your mortgage if you owe a mortgage, etc., get connected with Star C because they will work with you as a landlord to help your tenant, catch up on back payment. All right, we're going through a few more of these questions.
I saw a question in the chat. What to do if the landlord has not renewed your lease and hasn't stated that they don't intend to? Darius covered this a little bit. Usually when your lease is about to end, there can be provisions in your lease about how they need to notify you that they don't intend to renew. If they follow all of those procedures, then they are within their rights to evict you or request the premises. However, if they have not followed those procedures, and usually those are notice procedures, you may have an argument that you have improper notice. If you think back to the answer sheet that I showed in this earlier slide, one of the boxes you can check is, I did not receive proper notice. That is a defense. And so you want to be able to check that box off. If they have not provided you proper notice, then they have not properly, they were not authorized to file that eviction, and you have a good defense. I see another question about, I've received the filing after I had already paid what I owed. So I thought I was good, and the 7-day answer period has come and gone. Do I need to try and file a late response? Your best bet is going to be to go on to the Fulton County website's page and see if a default has been entered against you, a default judgment, or a writ of possession. If you have paid, that is a reason to ask the court to dismiss your writ of possession. And I would suggest you consult an attorney as soon as possible to try to get a writ dismissed or vacated. Because once that writ is issued, the sheriff didn't go to court. They don't know what the judges said or don't say. Their rules say they can evict you. So you want to try to get that taken care of as soon as possible.
I see a question here. Can I get evicted for multiple noise complaints as far as lease violations for noise complaints? And the answer is depends. It's a very lawyerly answer, but it does depend on your specific situation, how much notice they gave you. And if you're a public housing tenant, so if you receive Section 8 or some kind of other housing subsidy, you have greater protections than other tenants. So it's really way more difficult for them to terminate your lease due to a noise complaint if you're a Section 8 tenant or a public housing tenant compared to tenants who aren't covered by any kind of federal or local subsidy.
Another question that I saw was, what if I have no way to contact my landlord? I only have contact with the secretary at the rental management company. So we do see that as well, sometimes where we have to try to chase landlords down. One, if something has been filed against you, there should be in the court document, in the dispossessory affidavit, some kind of contact information for you to reach out to the landlord. It's not always the case. It's not always valid. Two, the Georgia Secretary of State's website has to list all businesses, at least, that are incorporated in the state of Georgia. And they're under, if you go to the Georgia Secretary of State's website, if you research corporations and type in the name of the management company, there should be a registered agent with a name, address, and preferably phone number that you can reach out to. If nothing else, send something to the address, the last address that you have. Spend the money on the stamp, spend the $1 on the stamp, send them something, make a copy of it, or take a screenshot to show that you have tried to reach out. I keep stressing it, but it's really important. We're lawyers and we like evidence. Evidence is your best friend. Pictures, screenshots, get a neighbor to do it. If you don't know how to do it, ask your mailman, ask the person who picks up your trash, ask your neighbor, ask your 10-year-old nephew who is very tech savvy. How do I do this? Because it will matter and it will help you in the long run. Could be a little frustrating. My mom is 71 years old and she still doesn't know how to do screenshots. And I will spend an hour on the phone with her to do it. And that's what you do in your family. So reach out to family, reach out to your pastor, reach out to whoever you know that you think can help you use this technology to your best advantage. Because other people are using this technology and they're using it against you. So you need to arm yourself with all of the tools necessary, no matter how frustrating technology can be. it's important, and it's that one crucial thing that matters when you get to court is the evidence you have.
And I saw a couple questions about from people who are just trying to find ways to help other people who are in need. We're always looking for volunteers. I'm sure Ayana can attest to this. If you're interested in volunteering, if you're if you're an attorney, or if you're just generally interested in volunteering, go to our website, avlf.org, and there's a volunteer tab at the top of the page, and you can find more information about volunteer opportunities there.
To add on to that, I would also just say spread the word in your community. There's a lot of people, especially those that don't have access to technology, that don't know about these opportunities. So just tell your neighbors, tell your friends, and tell them to tell everyone. So just any final questions, and then we can wrap up. And then thank you for all this great information and for everyone's questions to help us learn more. So tomorrow morning, you will receive a link to the recording. Like I said, please share this with everyone that you know, and we'll also link to some of the resources mentioned, and I'll try to get some specific mortgage information for those that are asking. Yes, so we had a video back in May that covered some mortgage protections and assistance, and I know the city's coming out with some more information tomorrow. So we will get that information and email it out tomorrow.
And very quickly, Jen, because I see it's a couple of homeowners on here. Make sure as a homeowner, I know it's going to be great to apply for rental assistance, but you can also apply for a loan modification as well. Reach out to your mortgage company as soon as possible. Let them know that you're struggling to keep up or pay your rent. You might be eligible for a loan modification. You might be eligible for forbearance. Or other mortgage assistance programs that are available to you as a homeowner. So definitely reach out to your mortgage company, because mortgage companies are supposed to tell you everything that you're eligible for. I know, I used to work on mortgages before I start working on eviction and so on and so forth. And I know that a lot of people, they like to avoid any kind of conversation about past due late bills, specifically with their mortgage company. But that's always a bad move. Contact your mortgage company. That should be your first step. And then your second step, if they're not telling you about loan modification, if you apply for a loan modification, but you've been denied, the Atlanta Legal Aid Society has a home defense program. They're based out of they're the CAB office, but they cover all homes in the metro area. So you don't have to live in DeKalb. You can live in Fulton, Clayton, and so on and so forth. Contact them, because they will actually help you or point you to the right direction to help with loan modifications and other assistance that might be available to you at that time. So definitely just keep that in mind. Reach out to your mortgage company. And if you really need help because you've already did all you can do, contact the Atlanta Legal Aid and their home defense program. They're based out of the CAB office of Atlanta Legal Aid.
Thank you for adding that. And I can add that to the email tomorrow too, their contact. So thank you again, everyone, for joining, your time and your questions. And then, of course, to Darius and Ayana for all that great information, and Terry and Rob for the intro. Please share. You'll receive the email tomorrow. And I put my email in the chat. If any of you were not on the original distribution list, just send me an email. I'll make sure you get that information. And I hope everyone takes care, stays safe, and gets the help that they need with this protection information. Have a good evening.